Question and answer time. How is my property transferred at death? This is probably the most common question that we get. The first one is, well, you have a last will and testament, and that last will and testament states exactly how your assets are going to be transferred from your estate. Because remember, once you pass away, all of your assets go into your estate, into the estate bucket. So your last will and testament will say who gets what out of that bucket. So you might have 3 kids and each one gets a third. You might have 3 kids and want to also give something to one of your favorite charities. Maybe the charity gets a fourth and your kids each get a fourth. It's however you want it. It's your last will and testament. Now, along with the last will and testament is a revocable living trust. Now, you guys know from watching my videos that I really like a revocable living trust centered estate plan. And much like a last will and testament, a revocable living trust will say exactly how to transfer the assets that are in that bucket to your heirs. The second way is beneficiary designations. You'll see these a lot on insurance policies, retirement accounts, or sometimes called pay on death designations on bank accounts that you have at whatever bank or financial institution that you do your finances with. That is simply a form usually that you fill out with your insurance company, retirement account, or your bank that says, if I pass away, I want my money to go to this person. I want you to write a check half and half to this person and this person. Those are beneficiary designations, and it's a really simple way to transfer the asset that you have in banks, retirement accounts, IRAs, financial accounts to somebody directly. And it's a really easy way to transfer those bank accounts, retirement accounts, insurance policies, IRAs, whatever those financial accounts are, to the beneficiary that you want it to go to without having to go through the probate process. So what happens is once you pass away, whatever financial institution it is, they will usually require a death certificate and some type of affidavit proving you are who you say you are and you are indeed one of those beneficiaries. And once that financial institution is satisfied that you are who you are and that you match the person on the beneficiary designation, then they will write you a check. The third way to transfer property is, well, just by operation of law. And what I mean by that is if you own a house with your spouse or your partner, you probably own that real estate, that home that you're living in, as joint tenants with the right of survivorship. And what that means simply is that once one of you passes away, the property automatically goes to whoever the survivor is of the two of you. Now, even though it's an operation of law, whoever the surviving tenant is, so let's say it's a husband and wife, the husband passes away, the wife is the surviving tenant. So even though she's a surviving tenant and the property goes to her, in most states, she still needs to file what's called an affidavit of surviving joint tenant. Now, what this is simply a form or a legal document that tells the world that you own this property with your husband, in our example, as joint tenants with right of survivorship, and that the husband has passed away. And so now, pursuant to operation of law, you're the surviving joint tenant and you're now the sole owner of that house, that piece of real estate. The fourth way to transfer property is, well, by state law. If you did not have a last will and testament, if you did not have a revocable living trust, if you did not have any beneficiary designations, or you did not have any property set up by operation of law, then we have to look at state law. And you've heard me say this before, we look to the laws in your state, whatever state you're living in, to the laws of intestate succession. And I can tell you guys, and you've seen it in our other videos, you probably won't like the way property is distributed under the laws of intestate succession, because it's a very strict statutory way of distributing your property. So we have had examples where people who have lived together for years and years and years, because they were never legally married or they never legally formed a partnership and they had no estate planning whatsoever, the surviving partner lost out on the entire estate. It happens over and over again. So always make sure you have an estate plan in place so that your assets that you've worked your entire life for are not distributed to somebody who you didn't want, or maybe that you didn't even know. I know I've thrown a lot at you today, so that's why we've prepared our free guide on estate planning. I'll put a link to it in the description below and in the comment section below that so that you can download it and get started in the right direction. And to help you out even more, watch this video up here and this video up here. If you enjoyed this video, then guys, please smash that subscribe button and click on the like button. And also click on that little bell so you'll get notified every time we post a new video. Have a great day and an awesome week. And as always, thanks for watching.